We'll go through a very short presentation to cover anyone who has an alcohol violation like minor in possession, public intoxication. All right, I'm going to start the presentation and I'm going to share the screen. And let me start the slideshow here. The presentation that I'm going to go over right now is how to handle an alcohol violation for those under 21. Currently, our court is closed. Well, is actually just open. The facility, our lobby, opened yesterday, May 11th. And so the goal of this video is to go over all your options. But right now, you can do everything remotely. You do not have to come to court. Our lobby is open, but you do not have to come to court. And so we have generously had rules implemented by the Texas Supreme Court, allowing us to work with you remotely. That's for your health, everyone's health, and it should give you more flexibility in taking care of a violation. Now, what is an alcohol violation? The most common violation is minor in possession. When I say alcohol violation, I'm talking about violations in which the defendant is under 21. So minor in possession is the most common violation we see. Minor in consumption, public intoxication. Now you can commit public intoxication over the age of 21, but this talk will be just focused on if you're under 21 and receive a public intoxication offense. Driving under the influence of alcohol, so driving a motor vehicle when you've had any amount of alcohol in your system and you're under 21, or misrepresentation of your age to purchase alcohol and you're under 21. Most of these violations, you will receive a citation. However, with public intoxication, the law demands that you get arrested. You cannot be given a citation for public intoxication due to the fact that an element of public intoxication is that you're intoxicated to such a degree that you may be a danger to yourself or others. So how do you take care of your ticket, or if you were arrested, how do you make an appearance at our court? It used to be that you had to come actually to our court. But now since the pandemic, you do not have to come to the court. And it's actually advised that if you can appear remotely, that works out best for everyone. You can call us at our phone number, area code 979-764-3683, Monday through Friday, 8 to 5, and talk to us and we'll go over your options and you can take care of your ticket that way. By mail, you can indicate your request, include your name, address, phone number, and email address. We have found that it's very helpful if you give us your email address because we can send you documents and you can send documents back as well. You can take a photo with your phone camera and then email that document to us. Since May 11th, you can appear in person at the court. But again, during the pandemic, it's advised to, if you can, to work with us remotely, but you can appear in our lobby if you wish. And finally, our website, cstx.gov/court, provides a lot of valuable information. All right, as I mentioned, during the pandemic, you do not have to appear in person for your citation. We can handle everything by phone. It's helpful to transfer paperwork back and forth via email. So it's helpful for us to have your email address. And if you really do want to talk to me, we can do a Zoom meeting if you want a more personal approach and have a question and want to talk to me. It's very easy for us to set up a Zoom meeting with you. How do you make your appearance? Well, there's two types of pleas you can make: guilty, no contest, or not guilty. Now, a no contest plea in our court is pretty much the same as a guilty plea. You're not contesting the charges, but you're not pleading guilty, but you're not contesting. it will be entered and you will be found guilty if you plead no contest or guilty. The other option is not guilty. And if you plead not guilty to the charge, then you'll be set for a pretrial conference with the prosecutor. And right now, our prosecutor is doing pretrial conferences via Zoom. So if you're able to do that, that works out very well. If you're not able to do that, or you just want to meet in person with the prosecutor, then starting in June or so, we'll be able to schedule the pretrial. But during the pretrial, you'll talk to the prosecutor. The prosecutor, you and the prosecutor may come to a plea agreement. The prosecutor has the ability to dismiss the case. Or if you don't come to an agreement, then we can set you for a bench trial where I will hear the evidence, or even a jury trial. If you plead guilty or no contest, then you have various options and consequences. Most people do not choose this, but if you are convicted of the alcohol offense, you will lose your driver's license for 30 days. You will have to complete an alcohol awareness course online, and you will owe a fine and court costs. Now, we can talk about the payment of the fine and court costs. We can talk about if you're indigent, about different alternatives to the fine and court costs, but those are pretty much the consequences of a conviction. Most people ask to be on deferred disposition, which is the other option, because if you're on deferred disposition, you're on 6 months of probation, and if you do everything you're supposed to, I'll dismiss your case. You don't lose your driver's license. You will have to complete an alcohol awareness course online. You'll have to pay a bond and court costs. Your case is dismissed at the end of your probation. However, you can, if you get your alcohol awareness course certificate in, have your bond and court costs taken care of, you can ask to have your case dismissed early. I'll supply my email address, you have our phone number, but you can ask to have your case dismissed early if you've done everything that you're supposed to. So the conditions for deferred disposition at present is don't commit a non-traffic offense. If you commit a traffic offense, that won't count against you on a deferred disposition. Pay the bond and court costs. And we can talk to you about when the payments due. We can work with you during the probation on that, or if you need alternatives. We have a video presentation similar to this on our court's YouTube channels page on how not how to close your case early, but also completely clear your municipal court case through an expunction. With a deferred, your case is going to be dismissed, but you still, if you had a public intoxication, you have an arrest record, you still have a record that you were on deferred, that you pled guilty or no contest. And through an expunction, when you turn 21, you can completely clear that. You will have to take an alcohol awareness course online. Now, at this time, other conditions that used to be by law part of an alcohol case, you do not have to do. So you will not have to perform community service or any live classes. We had a community living class and we had a victim impact course that you will not have to do due to the pandemic. You also will have a statement compliance due at the end of your probation. If you ask to have your probation ending early, you won't have to turn in the statement compliance, but you will receive a statement compliance that's due at the end of your 6 months probation, stating that you did everything you were supposed to. For expunctions, for a conviction, when you turn 21, you can ask to have your record expunged with a filing fee of $30. Now, the video that I have on clearing your case goes into more detail on this, but you don't have to be in College Station at the time to get this expunction. You can call our phone number and talk to us. We'll probably have you email the request, but for a filing fee of $30, you can have your record completely clear. For most people who complete deferred disposition and your case was dismissed, when you turn 21, you can ask to have your record expunged for a filing fee of $30. We'll again explain the procedure to you. You don't have to be in College Station at the time. Why do people seek expunctions? Well, we have found that people, especially college-aged individuals, care about an expunction. Now, a deferred means that you weren't convicted and I dismissed your case. But it doesn't mean that you don't have a record of a criminal charge. If you were arrested, a criminal arrest, that there's a record of you pleading guilty, and that you are on deferred disposition. And a lot of times graduate programs, graduate schools, law schools that you apply to, employers will ask, they won't ask, have you had a criminal conviction? They'll ask, have you ever been on deferred disposition? Have you ever pled no contest or guilty to a criminal charge? Have you ever received a criminal charge? If you get your record expunged, you can lawfully say that you've never had a criminal case, and we will completely destroy your record by law. And again, there is a video on this YouTube channel which goes into more detail about closing your case early, but also clearing your record through expunction. The clerks are very always stress to me how important it is, and will want me to remind you, please notify us of any address, phone number, or email change. This will most importantly help you. It helps you to keep in contact with us. If we don't receive something that's due, we will try to contact you. But a lot of times people change their address and they don't tell the court. And if we can't contact you, there can be consequences to your not turning things in or paying what's due. So please notify us. Giving us a cell phone number. Usually a cell phone number stays with individuals even if they make changes in address. And again, the email address is so helpful for exchanging documents and keeping in touch. All right. No question is a bad question. Please contact us. I'm giving you here my email address. If you have some question on procedure, please contact me via that email address, or you can call us at 979-764-3683. Again, no question is a bad question. We want you to succeed, and we will work with you to make sure that you do succeed as well. I appreciate your listening to this video, and if you have any questions, please contact me.